Good afternoon. My name is James Cousins, and I'm joined by Attorney Brendan Shannon, and we're going to be discussing the 2023 case law update. A lot of work went into this throughout the course of the year. Brendan and myself were reviewing decisions as they dropped every Thursday. We were reading them. We were figuring out how to brief them. We were figuring out what they meant for our practice. We were figuring out what it meant for our clients. We used a lot of these cases when they were hot off the presses. And so today, hopefully, will be very valuable to all of you. And as an additional bonus, all of you out there that are VIP members and our clients will have access to our substantial written materials where we briefed every decision that came down, and not just told you what the decision says, but we tell you what it means and provide you some context with prior decisions and other issues that may interact with them. Before we get into the meat of the presentation, I want to say that this is attorney advertising. This presentation is for educational purposes only. It does not constitute the formation of an attorney-client relationship, although many of you out there have probably made the outstanding decision to use us as your counsel. And that past results, however awesome they may have been, do not guarantee future outcomes. And I guess without further ado, we'll get into the materials. And we're going to start with new statute. Section 118A and 11.2 became effective 12/30/2022. I know that this is technically a 22 development, but it really came into effect in 2023. Both sections essentially say the same thing. And they're reactions to decisions from 2 years ago and 4 years ago, where the Appellate Division had heard cases in a third-party context and had concluded that rulings of the Workers' Compensation Board were going to be given collateral estoppel effect in the third-party action. The case, I think it was 2 years ago, was a biggie because the Workers' Compensation Board had made a finding of no further cause-related disability in the workers' compensation matter. And of course, given that collateral estoppel effect in the third-party action is significantly going to impact damages, and it did. So the plaintiffs bar, lobbying hard as they tend to do and getting what they want as they tend to do, managed to essentially cut off collateral estoppel effect. Now, the problem that we have from a comp perspective is that the language that they chose to employ also suggests that there may be problems with applying collateral estoppel or res judicata as between two workers' compensation claims. There was a decision this year where collateral estoppel was applied from one claim to another to disallow the second claim, but they managed to get around it because, as the statute says, you can't give collateral estoppel effect in any other action or proceeding, which would cover another comp claim, arising out of the same occurrence. In this case, the theory of the causation changed between the first and second claim. In the first claim, it was described as an accident, and the second or consequential injury, and as the second claim, the theory was a occupational disease. So it was deemed to be not the same occurrence, right, even though it was the same condition. So they kind of slipped that one through the narrow keyhole that was left in there, which is pretty ridiculous. But in any event, I mean, we still have latches. Equity still applies in a workers' compensation claim in other instances. You just now have to navigate it a little more carefully because the path is a lot narrower.
Definitely.
Yep.
Right.
And then I'm going to start our discussion of cases with a law offices of Melissa Day victory, which is the matter of Balbuena v. Rocco & Sons Ironworks. Next slide, please. This is a case, I guess I have to admit, this is purely a victory for the firm, which is extremely rare. The facts of the case are fairly simple. When we went to file an appeal, we noticed that the claimant's address, when the RB89 was prepared, said one thing. The RB89 was not set out to go out in the mail the next day. When the final protocol was completed and the double check was completed, we saw that the claimant's address had changed. And when we looked at the record later on, it turns out that there's something fishy going on in the case. The claimant's medical all reports the address to which we filed the RB80 and mailed the RB89, but the claimant had some other address. And of course, this is a New York City claim, so you can't be sure what the heck's going on with it. And it turns out in hindsight that what had happened was the carrier in the file had filed a SHROI. And it's possible to change the claimant's address by filing a SHROI with a new address. You can change almost any number of the underlying elements of data in the SHROI by simply changing them and filing it. And that's what had happened. The carrier had changed the address believing that this was the proper address. And so when we filed it with what turned out to be an improper address. The board denied review. saying that we didn't file it with the proper address because in the pendency of the appeal, claimant's attorney filed and wrote to change the address back. We made phone calls and found out from the board, who tells us essentially, yeah, that's what the address showed at the time, but that wasn't the correct address. We filed a motion for a full board when they denied review. The board then decides that they're going to penalize us and our client and says, bringing this further appeal is frivolous. Even though you may or may not have proved this, they don't really get to the merits. We're still going to penalize you $1,000 because we don't think this appeal is meritorious. Sort of as a matter of principle, we took it to the third department to prove that service was proper. But because we only were able to take our appeal up on our penalty, the merits of the underlying appeal never ended up being triggered, even though the third department's decision in Balbuena basically said the law firm appealing the penalty levied against them had very good cause. They seemed to buy our position pretty fully that we proved that we provided proper service and that there's this weird issue about the ability of a SHROI filing to change data in the system. And as a result, the penalty was rescinded. They didn't find that we continued anything without good grounds. And notably, when the board came to speak at the last major conference for NYSEA, one of the comments that was made during the course of the presentation by the board was, please be careful when you file your SHROIs because it will change a lot of data in the system if you get it wrong. So it seemed to be sort of a nod to the fact that there was not really good ground. Certainly the board didn't need to penalize us, and the Appellate Division didn't think so either.
Next slide. All right, so moving on to Gallardo v. Harleyville Insurance Company. This is a common issue that comes up, which is that in a hearing, if an adverse ruling is made, you have to note your specific exception to the finding. So, and that's to every finding. So say there's, a case is established for the back. You have to note your exception to the case being established for the back because say you're controverting the matter. Then awards are made. You got to note your exception to the awards being made. Basically, you just have to go through every single one. And then when you complete your RB89, the appeal, you need to list in one of the boxes. I don't remember the exact number.
I think it's 14. Yeah, 14. 15, yeah.
List out all the specific exceptions that you made, and the date of the hearing that you made the exceptions at. And the important thing to know, and that sort of comes from this case, is that 23A, which provides us with some protections with minor clerical errors, basically on the RB89. It protects us from things like that, but it doesn't protect us from something like this. So if you don't note a specific exception at the hearing, then it's not going to be preserved by 23A. So here, I believe it was, the claimant's attorney did not note their exception to an employer-employee relationship finding, I believe, and they weren't able to appeal that issue. They weren't saved by it. So this applies to all counsel in workers' comp, but it's very important for defense counsel.
Right. And you know what? If my memory serves, when we talked about 23A at the last presentation, one of the many predictions we made was we were dead certain that service failures were not going to be saved by 23A, and that is correct. That's not even a guess. You could have just you could know that from reading the statute. But we did guess that a failure to note a proper exception, particularly given how the board had worked on that, and had worked it into the regulations when they amended it. I mean, it made it into 300.13 B2 2 and 300.13 B4V, basically, two different spots where they said we can and we will deny review on a 300.13 failure if you don't note an exception at the hearing. So
it's very common.
All right, well, next slide, please. We're going to talk about Bureau v. Wolco Breaker Roofing Company. So this was a weird case, and we're talking about this case mostly because it's amusing to us that the board's ultimate conclusion was they couldn't understand why the claimant was appealing an apportionment ruling. They couldn't see any aggrievement or any sort of harm to the claimant, and so they weren't going to conduct a review. And we picked this case apart pretty carefully. What we basically had was an 06 claim for the back and knee and a 2015 claim for basically the same sites. In the 2006 claim, the claimant's given a scheduled loss of use for the leg, and then apparently goes back to work, has the 15 injury, and the 15 injury finally does it, takes them out altogether, and the claimant's given like a 60% LWEC. What seems to have been the motivation here from the claimant was he obviously wanted some kind of apportionment to the pre-capped 2006 claim so that he could establish an entitlement to lifetime benefits. Probably he had a high enough average weekly wage to demonstrate the max rate. So his theory was, I have this low cap on my capped claim. I'm going to run out of benefits.
He's getting close, it looks like.
And it looked like he was getting close. We were kind of like doing the math to see, assuming about 2 years worth of temporary benefits, he's closing in on the cap. He probably has passed it by now. And he wasn't classified with a high enough cap to go back and seek reclassification under the safety valve provisions because he was 59. He didn't get his 76. So at this point, he was just looking to collect something. And I think it was pretty clear. But for some reason, the Appellate Division either wasn't made aware of that or didn't buy it, that it was actually agreed. Yeah, because it was odd. They thought it was odd for a claimant to be appealing an apportionment ruling because that's typically just which carrier is going to pay.
It doesn't really pass the smell test.
Both the appeal and the decision are just, they just don't pass the smell test to me.
All right, next slide. Okay, so moving on to Shaquille v. New York City Transit Authority. This is an interesting one because I would think that some people aren't really aware of this, but there's obviously a timeline for contrary a claim. I believe it's 25 days under Section 25(2)(b) of the Workers' Comp Law. Now, that timeline does not start unless the board indexes a claim. And weirdly enough, the board doesn't index claims all the time. So theoretically,
particularly accepted claims.
Right.
And that's the weird part about this case.
The weird part about this case. But so just generally speaking, that means that you could have a case that could get controverted well after the ordinary deadline would have passed because the deadline never started because the board didn't index it. Now, the thing that's problematic about this case for our purposes, because I mean, I know I've controverted a claim outside of that deadline because of this, is that the board or the third department remitted this matter to consider the fact that the FROI, the initial filing, had an L code with liability.
Yeah.
So basically, it's going to beg the question of, does 25(2)(b), the actual statute, trump the regulations relating to FROIs and TROIs? I mean,
and codes on the forms.
My inclination would be yes, because it's statutory law. But
I'd like to say yes.
You're kind of reading between the lines in that case.
Well, what's funny is that we talk about a 25(2)(b) case every year that we do this, just because they happen every year, and we like to remind everyone that 25(2)(b) is sort of like an escape hatch. Right. I've contributed a case like 2.5 years after it was filed. And the thing is that those cases almost will never really discuss the FROI-SHROI filings. And by and large, FROI-SHROI filings have been sort of a silent matter by the Appellate Division because that issue doesn't seem to make it up there at the same time. And so some smart claimant's lawyer came back and said, you can't controvert this because you filed a FROI accepting this case with liability and began making indemnity payments. You didn't exercise a 21A. You didn't accept it perhaps as medical only or something like that.
Yeah.
And so like this case would ordinarily just be your typical 25(2)(b) reminder, except that now it's been remitted back to the board for the board to consider this issue because the Appellate Division said that the decision below was silent on that matter.
So what do you think? I mean, it's kind of a different area of law, but when you have 21A, you would need a SROI filing as well. That's basically accepting it.
Well,
there's an initial payment.
You'd file your FROI and you'd use a W code, and then you'd file and a SROI IP with a W code, right? So you'd have something to trigger 21A. It's a FROI 00, probably an N. I always like the N's, but I know a lot of our clients don't like the N's because it's really just an extra filing because you have to actually do something that's operative. But you could file the N and then file a SROI IP immediately, saying using a W code, which is where that code pops up as available, and start making payments. Then you've triggered 21A. But this one we're going to be watching because I have a strong sense that now that it's back in the board's hands, the board really likes EDI.
Yes.
And the board wants EDI, and it wants the regulations that operate EDI to control, because the more authority they can get out of the regs and the control of EDI, I think the more they think they can limit litigation and control case dockets. And so I suspect we're going to come back and find that the board will decide this matter and say, because the carrier filed the digital equivalent of a C669 accepting the case, they were precluded from taking advantage of the board's failure to index a claim. At the same time, the board has now announced that they're going to index every claim, which I cannot begin to tell you how much work that's going to be. And it was apparently a response to a bill that was that was passed and ultimately vetoed, where the legislature was going to direct the board through a new section of the statute that they had to hold a hearing on every claim within 60 days. And it was vetoed with the idea that it wasn't possible.
Well, they already can't keep up with the expedited calendar.
Yeah. So I think this is the board's designation of that they're going to index every claim is sort of a midway on that, but it also affects what's going on in Shikali's case, in the Shikali case. And so we'll report back to you. I mean, I'd love to find that they found 25(2)B was controlling and we could pull a denial on the case, but I don't think that's going to be true.
They do.
Next slide. We're going to talk about the Flores decision next. We selected Flores because, for me personally, I think it's true for you, Brendan. I always like to call out good lawyering when I see it. And the Flores case was good lawyering. Defense counsel in this case did a great job mustering the facts and hopefully managing the investigation. That's what we would do in this case. We like to manage the investigations. We like to help the client generate the evidence necessary. And in this case, we have a claimant who says something fell on him from a height, right? So obviously he's setting himself up for his really juicy labor law case, right?
This is a funny case.
This is a funny case. So litigation goes on, and the carrier actually accepted this claim for limited injury sites. Then it turns out that additional body sites are going to be raised. And defense counsel jumps in and says, wait a second, there is all this good evidence that we've adduced that this is not as significant an injury as the claimant's alleging it is by these additional body sites he's claiming. And so what we've got in this case is we have employer witnesses that said that were with the claimant that say on the record they didn't notice anything fell and hit the claimant. They don't notice anything fell at all. We also have a supervisor who takes photos and can't find any debris right away. Within 30 minutes of the accident, there's no debris nearby that could have possibly fallen on him. And another lay witness testifies there's no work being done upstairs. So if this thing fell, it was either the invisible man or like a tremor, right? So as a result, the board hears all this testimony and says, we are not going to amend this case. All of this evidence goes against the claimant. The claimant, they had photographs of where the claimant says he was hurt, and he didn't even really have a scratch on him.
Right.
So they're like, well, how could this possibly be a consequential injury? We don't even believe that there's an accident. If anything, I think that what we should be doing is that we should be, this carrier should be considering a 300.14 reopening to possibly ask the carrier, the board to disallow this case altogether. So good case, good lawyering.
Great case.
Yeah.
Next slide, please. All right, so I guess I'm sticking with the Transit Authority. We got Sanchez v. New York City Transit Authority, and this is a simple one. This is a reaffirmance of our favorite case, which is a matter of Padawan v. PAL Environmental. This is a case that we talked about last year. I believe it came out last year.
Oh my God, have we used this case so much?
So many times. I think it came out early last year, so we've been using it for almost 2 years.
Yeah.
Over a year. Anyways, great case, and basically the idea behind it is that if you have an occupational disease claim, then the medical has to adequately document the job duties and activities that supposedly cause the claimant to develop that repetitive use, occupational disease, whatever you want to call it.
The distinctive feature of employment.
Exactly.
The definition of an OD.
Yeah, and it's been strictly applied where, you can't just say repetitive activities, or you can't say, on feet all day or something like that, unless it's like there's true evidence that they were just on their feet all day. Yeah,
I mean, Padawan and Fox are are basically two of the most valuable cases that we've had come out in years, where the board has demonstrated a willingness to dig deeper into the doctor's knowledge and understanding of what is going on, and saying, like, anything that's an assumption in there, if it is important to drawing the chain of causation together, they can't guess.
Right.
You can't say, well, I really don't know the duties of a corrections officer, but I've watched a lot of like police dramas on television.
Mhm.
Well, I'm sorry. That's not what the claimant does every day. He
Right.
just told you he was a CO. What does that entail?
Right.
If you don't know what the claimant's job duties are more specifically, you should find and argue that opinion is speculative.
And there needs to be a link too. So say the doctor does a good job of establishing a sufficient knowledge. So they are documenting the amount of time spent per day doing certain activities and the motions that are being done. They have to discuss how those motions could cause an injury to the left shoulder or whatever, the rotator cuff, whatever's being claimed. And that's something that can come up in testimony too. And I'm glad you mentioned Fox v. Altmar Parish, because this case has a little bit of that here, because here the issue is that the claimant's doctor had a knowledge of one of the accidents that the claimant had suffered, but not so much the other one. And that's kind of the basis of Fox, which is basically not only does the doctor have to document a sufficient knowledge of the job duties, but they also, in any case, not just an occupational disease claim, they need to document or at least be able to say that they reviewed relevant prior records. Now,
Right.
It's very common that they don't. I mean, if a claimant had a prior claim and went to the hospital, surgery, the works, then those documents need to be reviewed if they're going to issue an opinion on causal relationship.
And a lot of comp doctors don't like to take the time to do that.
No.
They're not going to defer that opinion on causation.
No.
Because they're not going to, that claimant's not coming back.
Right.
He's going to see another doctor.
Exactly.
All right, let's go to the next slide. And we want to talk about coverage. If you guys have been watching the case update out there for any amount of time, you know that I have a thing for footnotes. And sometimes the most significant drama comes in a footnotes. And Puccio v. Absolute, I don't even know, Puccio v. Absolute Chimney has one of the most loaded footnotes I have ever seen in 11 years of reviewing case law.
Mm-hmm.
The facts of this case are very simple. There's a business owner who has a supervisor or an employee who's excellent. He decides that he wants to reward him, and this is where it starts to get murky. But part of the reward was that the employee Puccio is given a partnership in the business. Now, Puccio seems to believe that this is some kind of fringe benefit, like some kind of profit sharing agreement, that he doesn't really think of himself as a business owner. At least that's what he says in litigation. Whereas Absolute Chimney's carrier, State Insurance Fund, says, no, he's a partner. And the real issue here is that Puccio suffers a absolutely horrible injury and is rendered paraplegic. They file a claim. He files a claim. State Insurance Fund denies it on coverage, saying that they did not opt in. He's a business owner. They have a policy, but Puccio is listed as an owner, and there is no opt-in provision. And as you all know, default in New York State for owners and partners is, unless you opt in, you're not covered. You have to have an opt-in. You have to pay the premium for that. You have to go through the underwriting vetting for that to be opting in for coverage. State Insurance Fund says he's not opted in. Many rounds of litigation occur in the underlying claim over whether he's an employee or an owner. And ultimately what happens here is that the board disallows the claim and says, you may have believed you were still an employee, but you were listed as a partner, you got K-1s and filed partnership tax returns, and for all practical purposes and documented, everything that we have in documentation shows that you're an owner. And we also have a policy that excludes owners.
Right. In
the footnote from the Appellate Division, they reviewed this independently and basically found that they were forced to affirm it. They said, and then the footnote basically says, despite whatever misleading shenanigans that the original business owner had misled his employee to believe that he was only sort of a business owner, but not really, and that he was still covered, that NYSIF, the carrier in this case, was free to deny coverage because for all legal purposes, he was an owner.
And all they knew was that he was an owner.
Yeah.
Right.
And they did not believe they were insuring him because what they had from them showed that he was an owner and they were not insuring him as an employee. So the Appellate Division basically says in this footnote, the employer may have committed substantial fraud against this employee, inducing him to believe something that wasn't true. And now that we're at the business end of a catastrophic injury, he cannot avail himself of workers' compensation.
Probably will be litigation on that.
There probably will be some kind of lawsuit of some kind between the business owner and him.
Not in our field.
Yeah, not in our field. I don't know if there's any possible recovery, though, outside this.
I don't know.
It's terrible.
All right, so next slide, please. Moving on to COVID stress claims. Now, once again, I don't know how this has happened. I'm still sticking with the Transit Authority, and actually the same firm that filed the last claim. Here, I think the first thing that we should note before we even get into the COVID stress claims is that there was a case reaffirming the prevalence standard that we hate.
And it was a better decision this year than last year. They talked a little bit more about prevalence in a little more detail. They seem to be okay with it.
Yeah.
I really hate it. It's artificial. It's made up.
Right. And for those of you who don't know, the prevalence standard is currently the law of the land when it comes to COVID claims. If it can be shown that COVID was prevalent, you define that however you will.
And you have a pseudo public facing job. That's the second part of the test that they even like to avoid themselves.
Right.
Yeah.
Then you could get a claim established for COVID. So that's been reaffirmed, even though there's never been any sort of rulemaking on that issue or anything like that. The issue with the COVID stress claims is that basically this firm, there's 3 cases. They have different but similar facts. They're all or 2 of them were with the same employer, and the third one's with functionally the same type of employer. They claimed that they had developed anxiety as a result of their employer's response to the COVID pandemic. Now, these are Transit Authority employees. They're public facing. These claims had interesting to crazy facts.
Yeah.
I could agree.
Yeah.
Claims of not being provided proper PPE, being harassed, all sorts of things. Basically just claiming that they developed anxiety as a result of the stress that they were under, working out in public during the COVID pandemic and the early days of the COVID pandemic. I think it's notable here that the third department did not buy these claims. And
all 3 of them disallowed.
All 3 of them were disallowed.
And affirmed. The third department affirms the disallowance. Basically, these people didn't get COVID, but they got stress and some kind of psychological condition from either their fear of COVID combined with their employer's response or just their employer's response. It's all nonsense. We're still going to deal with actual COVID claims, but it seems like both the board and the Appellate Division are saying we're not going to deal with this nonsense.
Yeah.
These are not claims. Hopefully these 3 rulings convince the claimants bar to turn away these claims. Don't bother filing these claims. It's a waste of time. It sounds like you actually have some kind of different beef with your employer, and you're just trying to take it out through this. Most stress claims, if you've ever handled one, that they're just circuses.
Right.
By the nature of the claimants, by the nature of the claimants' attorneys that take them, by the nature of the defenses, sometimes even the employer witnesses that you have to bring in who are peers, it turns into a circus because you've come to find out that it's a fight about something else.
Yeah. There were 2 other sort of interesting things here, which the first is the board, to its credit, just applied the normal standard. They considered whether they were exposed to stress greater than what, their coworkers in the same line of work would be exposed to. And then I could be getting the language a little bit wrong. You might know this a little bit more. I believe one of them, there was a claim for an abnormal work environment or something like that.
Like a hostile work environment kind of deal. Yeah.
And basically the third department said that in those cases, you need to be basically directed to do something illegal. Or ethical or something like that, so they denied that. Yeah,
the standard of conduct, legitimate business purpose, right? That's one of the defenses in those claims is what action did you take? Was it a legitimate business purpose? If you make that's sort of akin to the punishment decisions. If you're going to exercise a punishment against one of your employees and they return and file a stress claim against you, if you can prove that it's a bona fide business decision and it has to do with nothing other than what you were actually addressing, and of course on the claimant side of the bar but it's always like, well, that's a pretext.
Right.
You say this is about X, but it's really about because, Y. And, no court is good at that. No court is good at that because, juries are probably even worse, I'd guess.
Yeah.
But, courts are just human beings. So none of us are good at deciding whose story is right or wrong. But if you give a legitimate business reason that somebody got disciplined, and that's that same sort of analysis.
Yeah.
All right, next slide. Let's move on to Ramirez's case. This is another case filled with drama. Husband and wife get married, live apart most of their lives as a married couple. He's in the military deployed. She's living in Florida. Mm-hmm. They try to divorce on more than one occasion.
Yes.
And they sort of fail at divorcing. Like they never actually consummate the divorce.
Right.
And so after enough time lapses and they live apart enough, husband finds a new partner,
yeah.
and has kids with her.
Mm-hmm.
And he's living in Alabama and he dies.
And interesting, I don't want to cut you off, but dies while the second attempt at divorce is pending.
Yes, the second attempt at divorce is pending.
Yes.
So he wants to marry his fiance and he's dead. So it comes to the board on a question of, does wife, although pending divorce,
mm-hmm.
get benefits, or does fiance? And the short answer is, and you could have guessed this from the beginning, the board doesn't care.
Right.
The statute says what it says. There's plenty of case law that talks about separated couples. Mm-hmm. They don't care. There's plenty of case law that talks about remarriage in the same context. They really don't care. Right. As long as you're technically not remarried, you could be living with somebody for 40 years. You're not remarried.
Yeah.
So they find that the wife, who hadn't been receiving support from this guy, they were divorcing, gets the benefits.
Definitely.
Fiance does not. Now, my note on this was ex-wife gets the bennies, even though she's really not the ex-wife, but the fiance doesn't. My question is, had anyone considered trying to establish the fiance as a dependent?
Which I think could have been done.
Right. I think maybe it still can be done.
Right. Yeah.
Right. So maybe she doesn't get the full benefit, but perhaps she can establish dependency if she could show, if we just assume perhaps a traditional sort of relationship where we have two working partners and one is paying for a certain amount of bills and perhaps support for the kids and some other things. I think she has a good case to establish dependency. So maybe she's not out altogether.
Yeah, potentially. And I think the notable thing with that case too is the court strictly applies the definition of a spouse, but they do consider whether there was an abandonment.
Yeah.
And here it was borderline, but they didn't find abandonment because I think there were facts that, the still wife, sort of ex-wife, was interested in working things out. They had agreed to live separated for a time while he was on deployment. And there was actually a reference, I believe in a footnote, to the military had some sort of record basically saying, yeah, these two should not live together.
Yeah.
Yeah. So I don't know. It's a very interesting case. I had to read it. I don't know about you, 3 or 4 times.
Yeah, I did just because it was entertaining.
It's entertaining, but it's also a little hard to follow. But a good one to discuss. All right, next slide, please. All right.
So I misspoke earlier. We were going to talk about
we are talking about this one.
Sorry.
This is the Brown case from this year, and it kind of relates to what we talked about at the beginning with Section 118A and 11.2.
Yeah.
I believe the amendment from the end of last year. And this is a case where the claimant made a claim for, the wrist and carpal tunnel, and the carpal tunnel claim was denied. And then years later, without any real new facts or new evidence, tried to get it in as under a different sort
as an OD.
Theory.
Yeah. Originally, it was claimed as consequential, and then it was reclaimed years later as an OD.
Yeah, and basically the board just denied it and said that you've tried to get this in once. It doesn't quite use the language estoppel or anything like that, but you're basically stopped from doing it again, especially without any real new discussion of the facts or new medical evidence giving a new credible basis for making such a claim.
And of course, this survives those amendments because it's a different occurrence.
Right.
It might be the same condition, but the theory of the claim is a different occurrence.
Mm-hmm.
All right. So let's talk about Kennedy v. Third Track. So this is another case where there is a claim and there's acceptance, but there's additional sites that they want to add to it. And the claimant says he basically fell into the pit. It makes me think of that show, Parks and Rec. He fell into the pit. We really didn't. It turns out it was a really small little crevice.
But a few inches.
Yeah, a few inches. But now he's claiming like, basically Blue Cross Blue Shield coverage. He's heard it everywhere.
Mm.
The carrier comes in and demonstrates through good work of counsel that he did maintain his stories, but his coworkers took a picture of the place. The coworkers refuted it in testimony. The hole was like only a couple of inches deep. It wasn't wide enough for him to fall for his whole body into. And the claimant had prior treatments that he had either forgotten or denied or was just lying about for one of the sites that he was raising, which was a neck. So the third department goes through all this and says, yeah, it's pretty clear this guy committed fraud. Yeah, it's pretty clear that these body sites should not be amended into the claim. But here's the problem about this case. The third department decides that despite the fact that the claimant lied about the mechanism of injury, despite the fact that the claimant lied about the severity of his conditions, despite the fact that he raised essentially fraudulent additional claims, they find that the board's imposition of a lifetime ban for what the board deemed to be multiple instances of perjury shocked the conscience. A lifetime ban shocked the conscience of 3 judges of the Appellate Division, Third Department, who really, they know more than most judges do about, and most regular line judges do about comp, but not as much as we do. This is a really standard penalty.
Right.
You commit perjury, you lie to a judge, you exaggerate the nature and extent of your disability, you lie to the doctors about the nature of mechanism of your injury, you're going to get a lifetime ban if counsel is worth their salt. And I don't understand where they get off.
Yeah.
Because it seems to me, and it's short shrift. That's the worst part. They just say that the penalty is disproportionate. Mm. Now, and they reverse it. Now, it doesn't mean that any discretionary penalty is bad. It just means that lifetime they don't like.
Right.
And so my feeling is that this one was decided early in the year. I'd like to go back and look at it and see, because I feel like something substantial is warranted.
Yeah.
If I was the board, I would go back and be like, fine, you get a 10-year ban.
Well, the case law that's commonly cited with a discretionary penalty, if you have dishonest testimony under oath, is that it strikes at the heart of
the legitimacy of the workers' compensation system. Judges can't just allow perjury to take place without punishing it accordingly.
Right.
And the accordingly part really should be left in the hands of the court to whom the lie was perpetrated, right?
Yeah.
I don't like when the Appellate Division tries to do this. They've also been kind of all over the place this year. As an aside, we did the math. The reversal rate this year was just shy of 16%, which is high.
Seems high. Yeah.
It is high.
Mm.
I mean, it's usually much lower, closer to 5 than 15.
Right.
So, like the third department has been feeling their oats. Yeah,
they were active last year. So
they've been feeling their oats.
I think it's a trend at this point, but
I don't know. There's something in the water. They've decided that they want to start getting real aggressive about some of this stuff.
Next slide, please. All right, so we're going to talk about one of my favorite issues. I think it's also one of James's favorite issues. So we've got 2 cases this year that we figure were notable. That's the gray area issue. Start off with Espinoza v. City Safety Compliance Corp. This is a good case, and it's one to be aware of because you can see it coming up, and it's something that can be avoided in some cases. Here we had a claimant who, he was in the construction industry. And basically, he clocked out and was crossing the street to his parking spot when he was hit by a car and injured. So, your initial reaction might be, well, he clocked out and he was in a public place.
He was on a street.
He's on a street, yeah.
One of the most public. He's probably jaywalking, too.
Yeah. But the issue here is that all this evidence came in that across the street, there was a partitioned off area where they kept equipment for the job site, where the claimant parked his car, and the claimant testified and the employer could not refute that he was instructed to park there. Now, this is pretty common. You'll see cases like this every once in a while where an employer will either provide or recommend parking that's technically off-site, and then someone will get injured on the way from the parking spot to the office or whatever,
right.
job site. and it can be established as, sort of being in that gray area where they're in a special, it's not really quite a special hazard, but it's, it's considered that the parking space is to the benefit of the employer if it's being provided.
Yeah. And I mean, this is one of those pathways cases, like there is a pathway from the job site to this location.
Right.
It might take him over a public roadway, but there was they talk about there was one way in and one way out. He was on his way to it. I mean, the being hit by a car is not a special hazard, but perhaps it becomes a somewhat special hazard at the point where, the pathway is narrowed.
Right. So the next one, Serrata v. Suffolk County Police Department. This one's a gray area sort of special errand issue, and I feel like James might have some comments on this one, because this one kind of is a little annoying in the way it sort of turned out at the third department.
Yeah.
Here, the board disallowed on a theory of it being a gray area case. So we had a claimant who I believe was a detective of some sort who gets a call that there's been a murder, and he, at like 4:30 in the morning, makes a call and just basically says, like, go do this stuff. I'm going to come in. On his way in, he gets into a motor vehicle accident, and he's just taking his normal route, normal commute to work.
And he's portal to portal. He was reporting to a fixed location. He
Right.
wasn't going somewhere else. He was reporting to his ordinary desk job. Like he wasn't going out in the field.
Exactly.
Yeah.
That's a great point, is that he's not an outside employee. He's not entitled to just...
Well, at some points he might have been, but at this point he was not.
Right.
He testified he was reporting to a fixed location. So he was portal to portal, and the board liked that.
Yeah.
Yeah.
And then the strange thing about this case is that the third department reversed, did not remit, and came back and applied a different legal standard by saying that he was engaged in a special errand, which is an exception that can apply.
And it was because he was the supervisor. No one had asked him to do a special errand. He was doing it on his own initiative. On his own initiative, because he was the supervisor. I'm sorry I know this is your case, but it is not common for the third department to look at a board analysis and reject the framework without remitting it back to the board and telling them, we think this is actually an X kind of, a special errand case. What they did here is they just said, it's a special errand. It was a special errand. He engaged the special errand himself when he called his subordinates and deployed them to do some investigating. And he may have been in a gray area, but this was a special errand because he was doing it at 4:30 in the morning, which is not his normal time. They came up with every reason and just said that we're going to apply a theory of analysis, a framework of analysis different than the board's. And we're not going to give the board the opportunity to comment on it on its own. We're just going to find it.
I think the other thing that can be troubling about this case, it does sort of potentially open Pandora's box to what could qualify as a special errand.
I guess that means supervisors can establish their own special errands at any point.
And there's a lot of work is done, on the phone or whatever outside of.
Right. I mean, they talk about him being on call, but I mean, the on call cases, I mean, the board went out of its way 5 years ago in the Love case to sort of poo-poo the on-call thing.
Right.
It's yes, we understand law enforcement are theoretically on call at all times, that we're not just going to accept that blanketly. What were you doing? Did you have a call? On call is one thing, but were you doing something work related?
Yeah.
It's it doesn't mean that you're on call all the time. You're 24/7.
So what do you think? Should we try and power through a couple of these before the grand finale?
Yeah. Let's push. So we've got a jurisdiction case. The only reason this is interesting is for some reason the claimant really wants us in New York, probably because we have the most ridiculous workers' compensation system. The injury's in California. The claimant lives in New Jersey. The employer's parent company has an address in New York where perhaps some business is done, but not the business particularly related to the subsidiary where this claimant works. Nevertheless, he really wants a New York comp claim. Strange case. The board affirms there's no jurisdiction.
Yeah.
Now let's also talk next about Wilbur v. Hamister Group. Hate this case. So when the board amended the statute, or when the legislature amended the statute in 2017, among the many things they did was they said that if a claimant is found entitled to benefits at the time that they're deemed classified, they no longer have to demonstrate labor market attachment. Immediately after that, all defense counsel worth their salt stepped forward and said voluntary removal and labor market attachment are two different things. So a working claimant who stops working is subject to a voluntary removal challenge, and the board has bought that on numerous occasions. Voluntary removal is a species of labor market challenge. Like
Right.
if you were going to teach this as a class, you would probably call all of these labor market defenses. Like you'd have pure labor market, American Axle, voluntary removal, Zamora, and then you'd have light duty job offers. Looking at the facts of this case, I thought it was going to go the exact opposite way. We have a classified claimant entitled to benefits at the time of classification. 2017 amendments apply. Employer offers a bona fide light duty job offer within the claimant's restrictions. They can accommodate him. He can come back to work. Claimant ignores it. The board and the third department said the 2017 amendments immunized him from that challenge. Unreasonable refusal of light duty is nothing like labor market attachment.
Right.
It has different elements. This is a ridiculously bad ruling. The panel who came up with this is wrong.
Mm-hmm.
The third department is wrong. I can only think that there was some kind of fatal defect in some of the briefs or something. I don't know what it is.
Right.
But this is just dead wrong. I hate it with every ounce of my being.
That's a troubling decision.
It is a seriously troubling decision. Now the question I have to ask myself is, does the voluntary removal challenges that we have case law, where the board says voluntary removal is distinct and different?
Right.
And it is, because it has a predicate issue, which is the claimant stopped working. Why did they stop working?
Right, yeah.
And then the second issue under Zamora is, well, look for work.
Right.
What the heck? The look for work part is labor market attachment.
Right.
It is American Axle.
Mm-hmm.
Oh, God. Okay. The last one on labor market attachment, and we'll
Second last.
Yeah, we'll skip. We'll do them both real quick.
Yeah.
Attreed, the third department has been messing around with labor market attachment for the last 3 years about when it can be applied, when suspensions can occur.
Mm-hmm.
It's like they've gone off the rails on this defense. And what it all really boils down to is the third department is treating labor market attachment like an affirmative defense. They're saying it's not valid until you raise it. It's not valid until the opponent, the matter's been joined. It's not valid until the claimant's had due process, and it's certainly not valid until the court's ruled. What Attreed does is build on a couple of cases from the last few years and basically says, if you raise labor market attachment and you ultimately demonstrate that the claimant's unattached, the proper suspension date is not the RFA date. It's not the date the claimant was ordered to produce labor market proofs. It's the deadline at which the claimant was supposed to produce proofs and either failed to do so or failed to produce appropriate ones.
Right.
So that is now when we get labor market. So if you want labor market suspension, you better file that RFA right now. And you'd better you'd be either pay attention to yourself or get in touch with your counsel and make them force it into a hearing as soon as possible, because you're not going to get the suspension until whatever deadline it is that the court sets for the claimant to produce proofs. And that's another reason why you shouldn't let the court set some sort of nonsense like 60 or 90-day thing. A claimant can be attached 1 day after they were found unattached, right?
Right.
Courts do that all the time. So there's no reason that a claimant needs 60 days to demonstrate attachment.
Right. The next one, I'm not even going to really talk about the case. I'm just going to talk about the standard because I think it's important for adjusters to be aware of it in case you're negotiating a schedule loss abuse. Under Section 15.3V, basically, if you have an SLU award for an extremity, so the legs, hands, arms, whatever, that's 50% or more, you can qualify for a classification type award after the exhaustion of that SLU award, if in the first instance the claimant can show that their continued earning capacity impairment is due exclusively to their established injury. That's something to be aware of. I think it's like a provision of the law that a lot of people.
It's right in the statute.
Yeah.
Yeah, it's right in the statute. What's cool about this, though, is Gonzalez reminds us that causal relationship burden for the loss, their inability to obtain gainful employment, is not a purely medical issue.
Right.
Because in this case, they said labor market attachment applied.
Right.
Basically, this claimant said he was unapproved. They were able to demonstrate he was unattached. They said, okay, you may have a 51% or higher schedule, and you may not be able to find work, but it's at least in part due to the fact that you're not properly looking for work or you're not properly attached. Yeah. And we're not going to give you 15.3V benefits, which, by the way,
there is a defense.
Yeah. I mean, there are potential caps applied to these as well. We know they terminate automatically at 62. 15.3V, it's just like we have to talk about it because it's like the most obscure section of the statute,
But
yet it's been popping up.
it could come up.
Yeah, it's been popping up. Now, we're about 10 minutes out to the end here, and we wanted to save sort of our grand finale. We may come back to other cases after we're done with it, but I want to invite a special guest. I want to invite Melissa Day onto the stage. Melissa?
Good, how are you?
Let's see. We wanted to bring Melissa here because, of course, we can't talk about case law for the year without talking about the Court of Appeals. And it turns out that LOMAD was the sole defense counsel to appear at the Court of Appeals this year on a workers' compensation matter. Big deal. And we wanted to finish on a high note. We started with a LOMAD case, and we wanted to end with a LOMAD case, Matter of Lazuli. Tell us about Matter of Lazuli, Melissa.
So Lazuli involved a claimant who in 2018 developed some problems with his right hand. The employer, Wegmans, paid him voluntarily temporary total disability benefits while he was out of work.
That's generous.
Well, I mean, he did hip surgery,
Yeah.
so you can presume a period of temporary total disability for a period of time after surgical intervention, but because it was one-handed work, probably was at some point during this 36-week period that he was off of work where perhaps he could have done some sort of light duty. But regardless, Wegmans didn't challenge the degree of disability, didn't get an IME. They paid him at the temporary total rate based on what they presumed his average weekly wage would be. The board issued an administrative decision eventually establishing the case for the right hand, set the average weekly wage, made the awards at the temporary total disability rate for the period of time that he was off, and they marked the file no further action. But in the meantime, the claimant, Lazuli, had developed additional problems with his left hand. And he, again, ultimately needed additional surgical intervention. Wegmans, once again, when he went out of work, they paid him at the temporary total rate. He was out for about 11 weeks. And then the claimant's attorney requested a hearing. And the claimant's attorney requested a hearing to amend the claim to include the left hand. And at the hearing, Wegmans requested cross-examination of the attending physician. Why do you think they wanted cross-examination?
Oh, probably because the medical reports on their face were nonsense about a TTD, right?
Well, that's one of the reasons. But they'd already paid the claimant at the temporary total rate because they'd already paid the claimant so many weeks of benefits at temporary total.
You want to limit PHP.
Correct. So presumably this file is going to end up in a scheduled loss of use award. Because there are multiple injury sites. I mean, you could potentially have an argument that you would limit the PHP to one of those injury sites, but there's a good authority actually that says that your PHP is going to be one period of PHP for the entire claim, despite the fact that you have the right hand, the left hand, the right thumb, the left thumb, everything involved. So our counsel, Brian Prince, partner at LOMAD, recognized that because there could be PHP, we wanted to cross-examine the doctor on degree of disability to limit Wegmans' exposure once the scheduled award came along. The judge said no. Claimant's attorney had objected and said that we didn't have any contrary medical, which is not the standard.
It's like the children's spelling block defense that claimant's counsel is always like, well, they paid it, so it must be right.
It was basically
unless we underpay.
Yeah.
Unless we underpay, then it's never right.
Over.
It's never right. Yeah.
And the judge, who's a judge I respect, he found that he didn't find a period of 11 weeks because that's what the second period of lost time.
Yeah.
When the claimant went back for the second surgical intervention, he found that the period of 11-week period of lost time wasn't unreasonable.
See, I'm just going to intervene for a second and say, listen, if you talk to any orthopod, right, in a quiet, dark place, they'll admit to you that there are studies that show that TTD periods after surgery and surgical results in comp claims are demonstrably objectively worse. So if you're going to have CTS surgery outside of comp, you're back to work in a couple days. This guy had 3.5 months worth of lost.
I did it.
Yeah, 3.5 months worth of lost time. And I know it's probably going to sound a little jaded, but it's always a reminder to defense counsel. It's so easy to spend other people's money, isn't it? It's so easy. If it was 11 weeks out of that judge's pocket, he'd be like, well, what the heck were you doing for 11 weeks? But it's not his money. He's not responsible for it. Anyway, I'm sorry.
So we appealed that decision because the regulation that says that you're entitled to cross-examination of an attending physician whose report is in the file. We requested cross-examination prior to an award being made or prior to that issue being made or determined. And the board came back and for the first time found that the request wasn't timely. And so really the board created a new standard for when you can get cross-examination, because what they said in the board panel decision was that the request was untimely because the employer made payments at the temporary total rate and then didn't request cross-examination until 3 months later. So the board's prior to this case, the standard had been under Ferguson, the third department decision. It had been as long as the request was made at the first hearing and prior to a decision on the merits on the issue, then the request was timely. And in this case, the board was finding you were basically, if you requested cross-examination after you'd already taken some substantive action on the file, which in this case was payments at the temporary total rate, then you were then precluded from cross-examining the claimant's doctor.
So they want us to not pay the claimants at the temporary total rate ever, so we can preserve our rights.
The underlying reasons for why our client decided that they wanted to pursue an appeal, because they do like to pay their employees at the temporary total rate while they're out of work, and that's they're receiving a living wage, even if they might be partially disabled. But that's subtext of the case.
Yeah.
It isn't really apparent from the four corners of the decisions. We appealed to the third department. The third department affirmed the board, finding that our request was untimely, and the third department went so far as to adopt some language from the claimant's attorney's argument at the board level, which was that our request for cross-examination was disingenuous.
Them's fighting words.
So,
Because I'll tell you, when I say disingenuous, I'm backhanding my opponent.
when we went to the Court of Appeals, we pointed out the sort of, the within the framework of the regulation, there's nothing that requires a request for cross-examination to be genuine. And if it's disingenuous, that you're not entitled to it. But what we really focused on was that the four corners of the regulation, they don't include any discretion on the board's part in determining whether or not they're going to grant cross-examination of an attending physician. So because the board is a creature of the legislature, it only has those powers that have been given it to it by its enabling statute, which in our case is the Workers' Compensation Law. So the Workers' Compensation Law gives the board certain enumerated powers, and among those is the power to promulgate a regulation. And the board has promulgated tons and tons of regulations.
Maybe too many.
Once it's promulgated a regulation, and the board has the authority to, come up with these regulations because they're felt to be in the best position in order to be able to implement the statute and to adjudicate benefits for injured workers. They're given that power to promulgate regulations. But once they do it, they're not permitted to ignore a regulation. That goes essentially beyond the powers that the legislature granted to them. And there's very good Court of Appeals case law, which says that once the board promulgates a regulation, it's bound by that regulation. And the board has the power to change a regulation whenever it wants. But what it did in this case was that it pretty much, it ignored the plain language of the regulation, which provides that if the employer or its carrier or special fund desires to produce for cross-examination an attending physician whose report is on file, the referee shall grant an adjournment for such purpose. And it was incredibly difficult for our opposing parties to overcome the fact that this is mandatory language. It's not precatory.
Did everyone in the room just flash back to first year of law school when she said the word shall? That's the thing
Neon lights go on.
Yeah, shall. See, that's what I remember one of my favorite professors talking about mandatory and precatory language. It's mandatory language is there for a reason, and it means a lot. Don't ignore it. That was what he always told us reading a statute. If it's precatory, be prepared. Something's gonna come out of left field, but it's mandatory, it's predictable.
That the board, that the court found that the board is without any, wiggle room with respect to requests for cross-examination. The court found that within the language of the regulation, as we argued, that because it says the referee shall grant an adjournment, you only have a referee present and hearing a matter if you are at a hearing. So, there's a requirement that the request be made at a hearing. And then the second a limitation on, or grant of authority to the board in determining whether or not to grant the adjournment for cross-examination is that there shouldn't have been a decision on the merits already, right? That wouldn't be you could really just make an estoppel argument or a latches argument.
I mean, yeah, you weren't going that far. Your position was just that, listen, we were at the first hearing where this was going to be addressed, and you're telling me that's untimely, right? I mean,
right. Well, so what we wanted the court to do was to adopt the Ferguson standard, which does say that as long as it's prior to a decision on the merits, then it's timely, as long as it's also needed.
yeah.
And that is what the court found. So the court reversed. We were also gratified that the court awarded costs, which is
That's a big deal.
unusual.
Well, I mean, the third department did call us disingenuous. So it's sort of like
they were only mimicking what the claimant's attorney said.
that was sort of like soothing the insult that they attempted to add to the injury of a really poor decision. I mean, and the other thing, I mean, the standard that's enumerated in Lasley is basically at any time before the judge issues a ruling on the merits, cross-examination can be requested. So they basically undid a certain amount of the rule to some degree, I think, that the board had put in place. Like previously, the board had said it was timely if you, at the first hearing where you had the opportunity to, you asked for it. Now the court in Lasley, the Court of Appeals basically says at any time before a decision on the merits is reached, you can request it and it's still timely, and an adjournment has to be granted. I mean, so I think that the court really did go so far as to say, listen, if we got a decision on the merits, we're safe, like this is done, right? Because that's just the common principle of jurisprudence, right? You need a final ruling, but they're basically saying at any time, yeah, up to that point though, it's timely. What I'm kind of confused about is, and I had this happen to me once. I know you've had it happen to you when you take something up and perfect it. Sometimes your opponent, particularly administrative agency, the board just done this before, will say, okay, we buy it, we get it. It's 11 weeks of TTD. We didn't realize you were going to be so upset that you wanted to go to the Court of Appeals. We didn't realize that this was going to be a problem. We kind of like the way the rule is right now. Maybe we'll give you your cross-examination. I still don't understand why, after just looking at the statute, they wouldn't pull it. I mean, I watched your oral arguments. There was a lot of fish flopping around on the beach from the attorney general and from claimant's attorney trying to answer the question, what are we supposed to do about the word shall? I mean, that was what the court was basically begging them to explain, how they could affirm the ruling or otherwise reconcile it with the word shall. And I didn't hear an answer.
Given a lot of discretion in both statute and in the regulations that they promulgate.
Yeah.
To carry out the statute's directives. However, that power isn't unlimited. And I think that the board gets accustomed to making lots of decisions and creating lots of procedures and rules,
right,
subtext rules.
Like subject numbers or circulars.
Exactly. It cloaks under its authority to exercise its discretion in order to be able to carry out the statute. And I don't disagree that the board should have that.
Yeah, I think so too.
Absolutely. But there comes a time when, if they've exceeded either the statute or a regulation that it itself promulgated, I do feel that we should push back. I mean, there's very little that we can do a lot of times when you're going up against the board with respect to challenging its authority to take certain actions. But in certain instances, I mean, when the language of the statute is clear, when the language of the regulation is clear, I feel it is really incumbent upon us to push back on the board, and otherwise, what are we doing here, right? I mean, why do we look at the statute? Why do we look at the regulations?
Right.
At that point, we just go up and show up and let the board do whatever they want to do. And it prevents us from really being able to provide any predictability to our clients with respect to the advice that we give.
Right. Right. Now, when I looked at this, I thought the result of this was pretty positive when it comes to resolutions, because, I mean, claimants attorneys want to cross-examine doctors as much as defense counsel does. I mean, yeah, but they do. right? So
Ferguson was a situation where the board was reversed by the third department because claimant's attorney requested cross-examination of an independent medical examiner.
right. I mean, it makes sense. And it also makes sense that we have mandatory language, shall. I mean, cross-examination of an adverse witness is probably one of the fundamental four corner tenets of due process. Right.
Mhm.
So, I mean, I don't think shall was an accident. I think shall was I think shall was a pretty intentional choice of words there. But I mean, if the parties are walking in, like in the situation you described, and they know that, like you can request an adjournment to cross-examine the doctor, and it's like a pretty common fact pattern, right?
Mhm.
He's got one hand that works. I get it. There's probably some time immediately post-op that he's TTD. Conceded, it makes perfect medical sense. But at some point, the standard of TTD is not going to be met, right? The claimant's going to have some work capacity to do something.
You're going to be able to get a concession from the attending physician that, I mean, there was certainly some work that the claimant could have done that didn't entail using one hand.
So if the parties all know that, like, listen, any proof that you adduce is really going to be subject to scrutiny, right? Doesn't that mean that the parties are going to be much more reasonable and not hide behind sort of what happened here? I mean, this was basically hiding behind a nonsense procedural ruling in an attempt to short circuit litigation.
I mean, honestly, I think you probably agree that that's had been my experience with many claimants firms before Lazuli, was that you could negotiate a period where the claimant would be found to be less than totally disabled after a reasonable period of time following a surgical intervention, and you would keep the
rate
partial designation at the temporary total rate, so there's no overpayment created or anything like that. It's reasonable, but it protects the employer because then they're not facing these periods of PHP. The claimant got as much money as he could get or she could get during the period of time that they were recuperating. I mean, there's really only one party, I think, in this scenario here that they weren't happy with the outcome.
Yeah.
And it was claimant's attorney. They want to maximize the award, the schedule loss of use award. So maybe I couldn't begin to attribute specific motivations to this particular firm or to the attorney that appeared at the hearing, other than to suggest that it's in the claimant's attorney's best interest to, or at least it used to be, in order to maximize the award that the money that moves to the claimant at the time.
You want to maximize, and you want to maximize the PHP opportunity.
There's also a school of thought that leads to the conclusion that claimant's attorneys benefit from hearings. And so, this could lead to a lack of hearings. Maybe that's the motivation. I can only posit particular scenarios that might provide the motivation. I can't ascribe it as a particular motivation to this firm.
Well,
so I do believe that this is going to hopefully lead to some more compromise findings, at least with respect to the specific client, because I have every expectation that now they're going to continue to pay their people at the temporary total rate.
Yeah, I mean, it's certainly
they have to, but they may.
It certainly benefits the ameliorative purpose of the workers' compensation law, right? Which is to ensure that employers pay as much as they think they rightly should and can, and maybe sometimes more, so that an employee who's going through this hellish system has an opportunity to alleviate some of the suffering, perhaps.
25% disabled. That doesn't, how do you live on, I couldn't, like trying to live on 25% of what you expect on your regular weekly checks. It's really challenging.
Sure.
Most people live paycheck to paycheck. This is an area, I think, of our system, which it's not necessarily the best system for our injured workers. I don't think that the solution that Claimants Bar came up with, which was that you're just automatically determined to be temporary, totally disabled, that's the solution. Not at least without some sort of limitation on the time, the amount of time that somebody could avail themselves. But if you have an expectation of going back to this job, and you're only partially disabled, I feel like this is an area where legislative action would be beneficial to all parties.
It just seems to me too like there's just a certain amount of I mean, obvious disfavoring of the employer and the employer's position here. Like the statute's almost written as though it distrusts everything that the employer may do.
Maybe that's earned, I mean.
I don't know. I mean, listen, I mean, it's just, there's
Capitalism is a very unfeeling system.
and I love it.
I know you do.
All right. Well, thank you very much for joining us, Melissa.
Thanks for having me. That's out of the way.
Yeah. All right.
Thank you, Brandon.
Thank you.
All right. Well, it's 10 after. I guess I want to ask the audience out there, do we have folks still out there? If you want us to go on, we can talk about a few more cases. Some of these are real
questions.
Yeah, we could take questions now too. There's some good ones. We've got the Delaney case on occupational diseases, which I thought was an interesting attack. We've got some schedule loss of use and timeliness issues. Not too much though. Do we have any feedback from the audience? No? All right, well then why don't we just open it up for questions? Do we have any questions? You can put them into the chat. We'll unmute everybody. Can we do that? Unmute everybody if somebody wants to offer some questions. Brendan and I would be happy to field them.
I feel like this is where we should cue the Jeopardy theme song.
Yeah, it is. This year, Brendan, while we're waiting on people, I want to say when we first started collating everything and putting everything together and rereading it, sometimes for the third or fourth time, I thought this year was kind of mundane. Lasley did come down late. So we didn't have Lasley until very late in the year.
Mm.
But for the first 6 months of the year, it seemed like we weren't getting a lot of fireworks.
Yeah.
And we had some fireworks in the beginning. All right, we got some questions. Do you think that the board will change the regulation after Lasley? So I had a discussion with somebody who indicated that they had maybe heard some rumblings from the claimants bar that they felt that the regulation should be amended. I think that's cutting off your nose to spite your face. I also think that the board probably, I don't think the board independently would want to. That's a guess. I'm not speaking for them. No one's told me that. But, the board is populated by attorneys who are very smart people and who know this as well as any of us. And the theory that you would take cross-examination as something less than a due process right, cross-examination of an adverse witness, I think that would probably stick in the craw of most lawyers, or at least I hope it would. That's the sort of thing that no matter where you work, plaintiff, defense, the administrative agency, the court, we can all agree that there are certain fundamental elements of American legal system, and that's one of them. So I'm sort of on the fence. I'm hopeful that it's just going to sit.
Yeah.
Because I feel that the board is going to react to Lasley largely the way that they reacted to Arias, which is just, or Tahar, it's basically like, okay, we were wrong in this instance to declare it untimely, so we're good to go because this really doesn't overturn our prior case law. It's single for this. We'll leave it alone. I guess I could also see them maybe putting out circulars to the judges basically saying, if somebody asks for it, you got to stop what you're doing and continue it. Yeah. It doesn't really happen all that often. Nobody goes out of their way to take testimony.
No.
It's like you have a purpose. You're not just requesting testimony. If you're at a hearing and requesting testimony, like shoot from the hip, something weird is going on at that hearing. Something very weird is going on at that hearing.
At least in my experience, judges rarely deny cross-examination.
Rarely. The judges treat it like Wegmans argued it should be treated, which is like, I really don't. Even if you happen to be one of the most imperious, like anti-democratic, anti-due process people sitting on the bench, I think you would still be motivated by a desire to quickly resolve something and make it sustainable on appeal and grant cross-examination. Like no judge wants to create reversible error by technicality, right? And that would be like an obvious technicality.
Yeah.
you know, and God forbid that whatever the basis for the request for cross has to do with some benefit that the claimant wants, like immediately, because then what you're going to get is this 23 stay pending the appeal.
Right.
So all you've functionally done is hose the claimant for however long it takes the panel to rule on what is a perceived technical defect pending appeal.
Yeah.
Why would you do that?
Doesn't make sense.
I mean, some of the most efficient judges that I've been in front of were extremely mechanical and would say things like, I want you to have all the record development that you possibly could want on both sides, because I want to make sure that we're going to get to a ruling on the merits without any technical appeals. Yeah, it's like if somebody has a problem with somebody else's request, let's figure that out before we have to file an appeal. Right? That seems to me like the most efficient way to resolve a calendar, right? And make them do it off calendar. Go do it all off calendar.
Yeah. So I don't know. We'll see, right?
Yep.
Is that all the questions?
We had one more question earlier. Will the board be indexing claims with medical report in C3 or C2? The answer is yes. The board talked about having basically the two elements necessary for a complete complete claim. I'm using air quotes, which is essentially something that makes reference to an injury. So either a C2 or a C3, or in a lot of cases now it's a FROI. Right.
Well, and a medical, right?
And a medical report, though, demonstrating that there's an injury, right? Yeah. And so that's enough to generate an indexing. So I guess, this time next year, we're not going to have a no claim. We're going to have a very small no claims file.
Yeah.
Because we know for years the board has collected all kinds of documents and all kinds of things that never got filed in a claim because there was nothing to, to link it or whatever. So, I feel for them having to do all that. I hope we didn't contribute to the need for that, because it seems like a really onerous task. I guess the functional result that we pointed out is that 25-2B is no longer going to be like that sort of like sneak one by. Yeah, sneak one by.
Yeah.
All right. Well, it's 1:17. We've come way over time. I'm sorry. I hope you were entertained. I hope you learned something. If we can go to the last slide, please, so that everyone knows where they need to go to get a copy of the materials. You can email us at mail@madwcdefense.com. If you happen to have my email or Brendan's, you can email us too directly. If you want a copy of the written materials or a copy of the slide deck, those will be available probably in the next week or so. I can tell you that the compilation of written materials is extensive. This year's is close to 60 pages, something like that. It covers every decision that's been published, not just a discussion of what happened in the case, but our comments on what it means and how it can be used. So it's instructive to you as somebody involved in the claims handling process about what that means. And of course, as we pointed out, we circulate these things monthly and make sure that they get used, even sometimes when they're hot off the presses. One of my favorite things to say. The AD just ruled on something that applies to this case, Your Honor.
Yeah.
And everyone's ears perk up.
And also, as you can see, we do have a YouTube channel. We do have other videos. Shameless plug. We have the Legal Scoop, which is my webinar series where I talk about recent wins that we've had here at LOMAD. And then there's also Melanie Daly's video series, The Daily Grind, where she basically just discusses notable things going on in comp. It could be anything, varied. So if you want to get access to those, you can either go to our YouTube channel or become a VIP.
Yeah, they're quick, entertaining, educational. I enjoy them. So again, thank you for your time today. It's a Friday. It's 1:18. Hopefully you're not getting snowed on like we are today. Hopefully you can get out of the office early and enjoy your weekend. Thanks, everybody.